question for Georgia. You mentioned the word mediation, and you don't hear it a lot when you speak about dispute settlement in the framework of free trade agreements or investment agreements. So could you elaborate a little bit more about that? What role is there currently? Have you you say you have statistics about that, but maybe also what do you think is the future role of mediation in the context of the European agreements? Thank you.
Okay, I'm afraid that I only have a limited answer to your question, because our study of mediation was limited in saying how often mediation is included in this dispute resolution mechanism. I can look it up afterwards because I have the tables on my computer, so I'll be able to tell you the number of. I have actually written a short paragraph of analysis on mediation, so you can read that. So I don't have the numbers here, but there is an increasing use of mediation. What is the future? Well, mediation is apparently very increasingly used on the national level, and as an alternative means of dispute resolution. I understand that in the United Kingdom, you cannot go to court before trying alternative dispute resolution mechanisms. Well, you can go, but you can be substantially fined if you don't try to find a solution outside the courtroom. So I would say that at the stage that is increasingly used, I think it will be increasingly used. That's what number says. I don't have other answers. So what is the future is something that I should look more into. It was not the precise subject of this. So
can I just follow up on that?
Yes, sure.
Can I just follow up, because we've also seen a tendency of taking away direct effect of agreements. Does that in turn have an effect on the possibility of going to mediation?
Well, mediation without direct effect means that you cannot, when there is, okay, let me reformulate that. The trend towards the abolition of direct effect is a trend that started, if I'm not wrong, in 2008, and it should be the Ukraine agreement. So from that moment on, the Commission decided that in all external agreements, economic external agreement, the European Union, and I think, if I'm not mistaken, but all the agreements I've read, they do now contain a clause prohibiting direct effect for reasons of protection and autonomy. I think, in my view, that is correct, but that's my personal view, and we can discuss about that maybe later. But does that affect? Well, we are talking about standing, so does that preclude? No, because almost government to government, they will still have to go through mediation. So direct effect does not have an impact. What it does, the issue is more general, meaning that in all agreements that contain an investor to state, so we are just talking about agreements that contain investment chapters or provisions, all those agreements where individuals do have standing, of course, if you in those agreements, they will have access to mediation. In all other agreements, with the no direct effect clause, they will not have access. So, no, I don't think it does, to briefly answer, and sorry if I took too long, but I was thinking with you. So, no, it does not, I think, have any impact. I don't know if anyone has different views.
Professor Castellar.
Yes, I have a question which is probably more a comment on Jean-Felix's presentation and also a bit on Georgia's presentation, is that much it concerned ISDS compatibility or incompatibility with EU law. And the question is, what if actually externalization is the only way to avoid the catastrophe scenario of incompatibility? I explain myself. This externalization has not only been affirmed but strengthened throughout recent agreements, from Korea to TTIP drafts. And when you look at the Commission documents on that, you get the impression that actually the Commission is trying to follow the roadmap of the court, of the ECJ, given in Opinion 213, at least 3 points. First of all, EU law is not applicable law at the international level. Secondly, international courts, international tribunals don't have power of injunction. And thirdly, there can be no procedural overlap between domestic proceedings and international proceedings. So overall, they try to avoid all possible overlap. So I wonder if externalization, notwithstanding its problems, has benefits which are simply not negotiable.
Alors c'est vrai que j'ai pas pu trop détailler cette question, étant donné du peu de temps qu'il me restait. Oui, il y a ces 3 points qui sont suivis, mais de mon point de vue, une juridiction internationale qui peut connaître de la compatibilité du droit de l'Union avec un accord international dont elle est la juridiction suprême, il est quasiment impossible maintenant de répondre aux exigences de la vie de 13 tel que je le comprends. Pourquoi ? Parce que s'il y a un problème, les trois éléments que tu as mentionnés, effectivement, il me semble satisfait. Mais il y a un élément qui est quand même central dans la vie de 13, c'est la question de l'interprétation. Et le problème, c'est que il y a beau y avoir écrit que pour ce qui concerne le CETA, que le tribunal des investissements statuera en fonction des interprétations que les juridictions internes européennes et canadiennes retiennent de leurs normes de leurs normes internes. Eh bien, le problème, c'est que on part du principe qu'il y a une interprétation dominante. Et s'il n'y en a pas, et ça, la Cour de justice, si elle est ferme avec sa position dans 2.13, eh bien, elle dira, c'est toi, tribunal des investissements CETA, qui va décider qu'il n'y a pas d'interprétation dominante. Et si tu constates qu'il n'y a pas d'interprétation dominante, tu peux pas me consulter, moi, Cour de justice, pour me demander. Oui.
If I may, I think there is another problem that you didn't stress with those mechanisms. It's related to Article, if I remember well, it's 8.23 of CETA, which states that an investor who wants to sue the states before this tribunal must waive its rights under the internal procedures. That means that the investor should renounce or waive completely its internal rights, so he will not go before the national court, and the national court will not be able to use the preliminary ruling procedure. And that, from my point of view, is totally incompatible with the case law of the ECJ, not 213, but 109. And I think that's the main problem with those mechanisms, and that I agree with you. This is a ground for incompatibility, a clear one.
I think just the difference between the patent jurisdiction and the ECHR is, for me, the ESDS are more similar to ECHR because the EU law is contested. The patent jurisdiction, the EU law is applied.
Yes,
and
but
it's an important difference.
Through the European Court of Human Rights, you have the exhaustion of local remedies condition that you don't find under those investment tribunals.
Yeah, but what was stressed in 109 opinion was this international jurisdiction has the power to not control but apply intellectual property union law, and it's a different logic because it needs the preliminary ruling in interpretation, and that's not really a problem that we meet when we deal with investment with ESDS. It's not really the same kind of problem of interpretation to my mind, but still there is a problem of interpretation.
Something. So this is what I said before I wouldn't have touched during my presentation, but now I have the opportunity to do it. So issues with national system. I do not think that national systems are possibly a way around an international court or international dispute resolution mechanism in the European Union for obvious reason of autonomy, but there are a number of profiles. So we have impingement in the autonomy, and what is the alternative? So let's think about alternative scenarios. So we have the possibility to have, first of all, we should overcome the issue that we have already mentioned of non-direct applicability. So let's think about what would happen if an international investment treaty, if FTA would be applicable. What would happen? These international agreements are so are phrased in really broad terms. So in the moment that we have such broad terms, it would be a disaster to have issues the application of specific cases, so not the interpretation of the general rule, but that general rule should be applied in specific cases, in specific jurisdiction, in treaties that are phrased in such broad terms that we would have so many different interpretations across the different national courts. So that's one of the problems, without going through the different profiles of incompatibility with the autonomy of EU law. Then there is another issue of unity of international plan of the European Union external position. So if the European Union, the strength of the European Union, the economic strength on the international plan is in its unity, the unity of its position. So in the moment that we fragmented and we have different positions taken from different member states through a judicial scrutiny, we somehow, I think, fragment the position, the general position on the European Union international level. Also, there would be, I think, a problem of intra-EU problem, thinking that, let's think about an investor who has to place an investment in the European Union. I mean, let's be serious. The investor prefers to invest in Germany. Rather, I'm Italian, so I can say it, rather than Italy. Because if we have different procedures, judicial procedures, the investor will think in the overall cost of his investment that he prefers to invest in countries that have possibly a more efficient system rather than others. That's what I think. And so we would have investment placed also on the basis of these considerations. And one more thing is that national courts are not necessarily better than international courts. Meaning that national courts are, if we take any report, they are the annual report on the efficiency of national judicial systems. There are some situations that are the Italian judicial system is, I think, possibly worse than in investment court, because the time for decision, for example, would be so long. There are problems of transparency. Truth is that autonomy, can we preserve the autonomy completely? I don't think any international court does impinge on the autonomy of EU law, so we have to find the middle ground.
Thank you.
Sorry.
Thank you. I will give the floor to Louis-Marie Chauvel.
Yeah, I have a question about this question of compatibility of ISDS with EU law. Don't you think that there is a difference between ISDS and ICS from the case of Opinion 109 and 213? That is to when an investor chooses to use ISDS in spite of a national system, there is a shift of judicial authority, but there is also a shift of the rules that are applied. It doesn't, and the ISDS tribunal won't apply EU law and won't apply national law, but will apply an international law. I can't find my word. An international bond that has been taken by the European Union and member states, and that would avoid some of the problems of autonomy. And if there were a decision by the European Court of Justice that would say that ISDS is contrary to autonomy of the European law, it would be therefore very difficult afterwards to have any international litigation system.
According to me, there is it's not a question of a law forum, but of adjudicative forum. And also there is another problem, is that those rights, those substantial and procedural rights, are reserved only to foreign investors, not to the national ones. I mean, I will give you an example. Bombardier will have rights under this agreement that Alstom will not have. So you have clearly here a discrimination. In my point of view, democracy, for instance, is related to one big principle, important principle, is the equality before the law, which is recognized under our constitution, under the Declaration on Human Rights, under the EU primary law. You have several provisions on that, and according to me, this is a blatant violation of those principles, of the non-discrimination principles. That's for the court to judge it, but I think there is a ground here. So, sorry, you wanted to.
Thank you, Mr. Chair. So I have a question and a brief comment, if I may. I will start from the brief comment that follows up on actually your remark concerning the waiver of local remedies that the Court of Justice has actually used in Opinion 215 to affirm the existence of a shared competence on the part of the Member States. However, the Court did not say anything concerning compatibility of the whole agreement, of course, and in particular of this provision with EU law. So it has been suggested as a reaction to this statement of the Court that it would be sufficient to overcome this obstacle and make it an exclusive agreement by inserting a exhaustion of local remedies rule in EU investment agreements, which, however, in my opinion, would be rather useless in the context of these agreements, provided that there is a clause that prevents the production of direct effects of these agreements. So I really don't see what would be the usefulness of this provision, and probably and also when it comes to compatibility. So the way I see these clauses, they are included in order to avoid simultaneous proceedings. So to avoid that an investor sues a government on the basis of a national law before a national court, and at the same time sues the state before an international tribunal. So I think that's the main function of such a provision, which I don't think would increase the chances that these agreements are incompatible with EU law. But that's of course just my opinion. But the question then is for you, Georgia. So you seem to have suggested very briefly, although in the form of a question, in your presentation, that a reformed ISDS would be preferable than an investment court system, and you referred to essential reasons of feasibility. Is that the only reasons, or there are also more systemic, so to speak, reasons that would, in your opinion, make a reformed ISDS preferable? So.
My question is, I put the question mark because I really still do not know. But this is my view, and this is what I've researched so far, what some readings suggest. So my personal view is that, theoretically speaking, an ICS would be the ideal possible dispute resolution mechanism for the European Union, for a number of reasons, and I will refer you to the writings of Karen Alter on the point that have really suggested me, actually. And because if you if you look at the aims and values of the European Union on the international plane, you will see also that there is like this necessity to interact with the international law and to export. So the ultimate aim of the European Union international plane is exporting its values and its democracy, democratic values and representation, and also its horizontal policy is balanced between horizontal policy and economic aims, so sustainable development. So I think if you look at the more theoretical issue of what is an international court? International courts, the way you design international courts is a way, is like creating a tool that ultimately can shape international law, because that court, if you shape the DNA of that court by procedural means, by creating, for example, a hierarchy of values. For example, I think in the ICS is the transparency rules and every transparency rule participation. They somehow take the international court would have the ultimate aim of taking the international court to not privilege necessarily economic aims on horizontal consideration. You have shaped a tool that in the relationship with third countries does exactly what the treaty says. So it takes your values, your hierarchy of value, and take it abroad. Clearly, in very general terms, you cannot say, independence would forbid you to tell the court what it has to say, but if you shape it well, it might be a tool of exporting your values. So, to answer to your the brief answer to your question is, I think the ICS would be the perfect tool, but we have to think about feasibility. So, thank you.
Oui, je voulais juste apporter mon point de vue sur cette théorie du parallélisme des procédures, de la simultanéité des procédures. De mon point de vue, je ne pense pas que c'est l'élément déterminant. Cela aurait pu l'être si l'exclusion de l'effet direct avait été limitée au chapitre investissement. Or là, en l'occurrence, on a une exclusion de l'effet direct de l'ensemble de l'accord. Donc je pense que l'argument de la simultanéité des procédures n'est pas forcément la première motivation.
Other question? Yes.
Well, thank you all for the excellent presentations, especially to Professor de Nanteuil, who played the devil's advocate and who actually made a remark that kind of surprised me, and I would like to ask you a clarification about it, because if I understand correctly, you argued that trade agreements are more problematic than investment agreements in terms of the respect for the right to regulate.
They're not necessarily more, but there are
as well.
I'd say.
Whereas I understand that generally accepted, I'm not an expert in this field, but I understand that the generally accepted opinion goes somehow the other way around, because, well, the WTO, dispute settlement body, and the appellate body in particular, tend to show certain deference to the states.
Yes, but does not apply it.
Excuse me?
It shows deference, but it does not apply it. I mean, if you take the results of case law, it's just a very. I mean, I didn't go in depth in the reports, but what I just noticed is that when you have an environmental measure, for instance, that is attacked in front of WTO, then it may lead to the responsibility of the state, then countermeasures, etc. Whereas in front of arbitral tribunals, once again, I have very, very few examples of environmental or health measures that have led to a condemnation of the state. So this is very description, you know, I didn't go further, but it's just that at first glance, I'd say that states are more condemned for general interest measures in trade matters than in investment matters. It does not mean necessarily that the threat is not is different, but this is, you know, surprising, and this is never really this has never been explored.
So the problem is more about the way arbitral tribunals make their arguments. Because, well, the way I understand it, the problem is not really the way the decisions go, either in favor of the state or in favor of the exporter or the investor. It's maybe linked to the problem of well, the regulatory chill, but since the case law of arbitral tribunals is to a certain extent imperscrutable, unpredictable, it is very probable that a state might, well, be deterred from introducing public interest legislation, not knowing how an arbitral tribunal might decide. And I make a practical example, Vattenfall. I mean, would you bet that Germany will win? I wouldn't.
No, because the Constitutional Court said that in any way the decision was contrary to the Constitution of Germany. So let's say if it's contrary to the Constitution, it is likely to be contrary to international law of the BIT between, I think it's Sweden and Germany. No, it's the Energy Charter Treaty. Anyway, the predictability is one thing. I'd say the appellate body, the ICS, is kind of an answer to that. As well, because if you set up an appellate body, then it will unify case law within the treaty. But this raises the question of the relationship of the different ICS between different treaties. If it's not the same, if you have one for CETA, another one for EU, Vietnam, so who will sit there and will they you know what I mean? So this may be an issue as well. But once again, I just want to fight against some cliches as well. There are some unpredictability, but unpredictability is really the heart of case law anyway. When you know case law, when you read arbitrary case law, and I do read it and I suffer for it, I can tell you that actually arbitrary tribunals, they really use precedent, they use former awards, they try to build case law. There are some mistakes, there are some very bad argumentations, and there are really some mistakes, but the Conseil d'État, the French Conseil d'État makes some mistakes when you come to international law. So, I mean, well, yeah, I just want to put some shade and to reduce some criticisms that sometimes are really, I'd say, too strong to be true.
Sorry, if I may, when you speak about policy space, I think you should also consider the implementation procedures under the two systems. Under the WTO, you have only prospective remedies, and remedies, I mean, it's not really remedies, it's only suspension of concessions and other obligations, meaning that most of the time you will reduce your tariff concession. This way, the EU could resist during more than 2 decades in the hormone case, during 1 decade in the GMO case, during more than, I think, 3 decades now in the banana case. So the EU kept room of maneuver against those decisions, even if it violated the WTO law. If those cases had been raised before NICSID tribunal, the penalties would have been calculated retroactively and would have been much more, I mean, would have influenced much more the behavior of the state or the union. So I think the policy space question should be looked also through this aspect.
Yeah, that is perfectly true, except that I don't know how, because the WTO system from that point of view is really great. I mean, this is really clever and interesting, but I don't know how we could translate such a thing to investment matters. This is international litigation, as you said, so you can just, well, say if there has been a violation, and then you draw consequences that is reparation. But yeah, you are totally right on that.
Isabelle, had a question? No? Last? Yes? One last question or remark? Okay. So we will finish. Maybe you want to add something? Conclude?
Thank you very much. We just would like to thank all the contributors for their very stimulating presentation. I think we had 2 very interesting days of work, so thank you very much for all of you. Our work is not finished because Cécile and I will come back to you quite soon for the publication and the editing of the book coming from the conference. We don't have the details right now because we still have to discuss it within the network. It will be, for sure, we have the agreement of Elgar Publishers to publish a book series of the three conferences of the network. So it will be in this publishing house, but we don't have the date right now. We will discuss it. I hope it will be quite soon because the topics we discussed today and yesterday were very actual, and especially Opinion 215, and I think it might be interesting that the book comes out quite soon. So I hope you enjoy your stay here in Rennes. We wish you all very good trip back home. And for those who stay tonight and leave tomorrow, enjoy your evening in Rennes. And so, see you next time.